I guess first off, I'll start with introductions. My name is James Miller. I work for Ogletree Deakins, which actually is a national law firm. I'm the managing shareholder of the Fresno office. Ogletree Deakins is huge. We are in every state, and we have about 1,060, and it kind of grows. It seems like every week. Attorneys. And so we're pretty large. Labor employment, defense only side. I have been practicing for 25 years. I've mostly been a litigator. I've done a lot of different work, different areas of law. A lot of ag though, because where I'm from is from Fresno in the Central Valley. Probably a lot of you guys have been. We're just down the street from the World Ag Expo, which is in Tulare. It happens every year, and so we grew up a lot of ag, a lot of dairies. Kevin and I both came from a smaller office from an attorney named Tony Raimondo, which is pretty well known, especially in the dairy industry. He's chased basically all the unions out of ag and dairy out of California for the most part. Now they're coming back, but and I learned from him. We purchased a firm in Fresno, and then from there moved into Ogletree Deakins. And my decision to do that was a couple. One was just as they talked about before, technology and AI is a big deal, especially in law too. And so we're trying to stay competitive. Dealing with big law has the resources to do that, and so for us to stay competitive, we decided to move forward. Also, Ogletree, although they represent like Dairy Gold here in the state and some big dairies and big farms, they weren't really in ag as we were. I would say that even our small little office of only about any one time 5 to 7 attorneys probably represented more dairies in California than any other law firm. So we do quite a bit of dairy work. We have Western United Dairies is out of there. We represent a lot of them as a membership deal. So we do a lot of the litigation, but a lot of also the starting out in the business aspects of how to navigate labor and employment in the state. Now we are from Fresno, from California. We have office in Seattle, here in Washington. Like I said, we have one in almost every state, and so we can practice out of all those states. I usually would have a Washington attorney here. We don't have one today, but we work very similarly with them or closely with them. And in California is a good place to know as far as the laws goes, because as you guys probably know, unfortunately, sorry guys, it's all moving up, right? California influences Oregon, influences Washington, unfortunately. And it's a nightmare, to be honest. Labor employment is very difficult, especially it's hit really hard in the last 5 years, I would say. In the dairy industry, I'm talking lawsuits that wipe you out completely. Three generations of dairies gone in one lawsuit. Kevin has seen it, I've seen it. I've done a lot of, I've been doing bankruptcy since 2009 as well. And so it was kind of primed to navigate that and use it as leverage. You know, with greedy plaintiff attorneys, what do they want? Money, right? So if you're gonna file bankruptcy though, then you're not gonna have any money. So I used to use that as leverage to try to get them pulled back a little bit. We also use, although as greedy as these plaintiff attorneys are, a lot of them are trying to make a living themselves, and so you try to explain, these are 3-generation families, small dairies, and here you are taking one worker that probably was their worst employee, right? Going to knock out a whole dairy farm or a farmer based on a stupid allegation or small allegations that are multiplied because our legislatures are not thinking ahead and giving too much power to the employees. So the pendulum has swung, guys. It's definitely, if you've seen it, it's with the workers. There's no doubt about it. I think Gavin Newsom just came out with a new law that fixed one of the PAGA. We have a Private Attorney General Act claim in California, which is really egregious. Luckily, Washington doesn't have it. And I'm hoping that because California has started it and it's wreaked havoc, that other states will see how bad it is and not jump on that. It basically is additional penalties on violations on top of already the laws that are there. California jumped on that, trying to give empower more of the employees, and it's been extorted, to say the least. So I will say this, I'll admit to the fact that I have done plaintiff's cases, as Kevin has, a little bit, based on the class action side, not in ag or anything, not in dairy. We did explore around with it for a few years, just thinking that it would be better to be on that side to understand it. We did a few, but we don't do it anymore. But the good thing about that as learning is what is targeted. As a plaintiff attorney, you guys need to know why is it that attorney picks on you, right? There's tons of dairies, and why maybe they might pick your dairy to sue versus others, and that's one of the things we're going to go over. So let me have Kevin introduce himself, and then we'll start into it. You got this one.
All right, hey, there we go. Good afternoon, I'm Kevin Piercy. I've been practicing in California for several years now. As James said, we've been doing predominantly labor employment for the ag industry. We handle everything from large employers of 28,000 plus employees down to small dairies with a handful of employees. We've taken care of helped squash out a lot of these kinds of lawsuits that have come up. And unfortunately, we've also had these times where plaintiffs' counsel, as I said, have come in and wiped out some of the businesses. So what we are bringing here is we are bringing what we've seen, the tactics that are being used, and we can bring that knowledge here. Because unfortunately, what's going on with the plaintiffs' counsel all throughout the state or all throughout the country is they all get together their national conventions in like Vegas and these other kind of venues. And who are the people that come up and teach them how to be, good plaintiffs' attorneys? It's the California guys, because they have all the experience. They bring all that with them. So we can do the same thing on the defense side, because we know what the plaintiffs, what they're like, what they think, how what they go after, and we can help you guys to kind of shore up your defenses here a little bit, and we can protect you as best we can with some general strategies going forward. So
Kevin is Kevin's a military guy too, though, for your veterans out there. I like to say that just because I hire a lot of veterans. I like the veterans. They stay in line and are loyal. No, I just look up to that. My dad was a Marine, 20-year Marine. I never went in and served, but I was living on base. I was a Marine Corps brat, and I always feel comfortable with the veterans and guys. So we have a couple of them, and Kevin's one of them. So he didn't want to say that, but. Let me go. I do want one disclaimer. Remember, we are in every state, and you do. I don't know. Some people come from different areas. Make sure whoever you talk to, you do talk to the attorney that's in that state. Like I said, our firm is in every state, so that is helpful. We're usually the first point of contact, usually, and then if I need to work with other states, I'll do that with their attorneys. But California is the most egregious, so it's kind of helps with us because we kind of know where the law is going and how it proceeds forward, because a lot of plaintiffs firms, like Kevin was saying, starts from California, and then now they're recruiting attorneys with licenses in other states because a lot of the laws are changing, and they're going, they're just going to keep chasing the money. So that's one disclaimer. One thing I did want to, it was already talked about earlier about how important dairy is in Washington, and I was doing my research on it, and I was really surprised how big dairy was here in Washington. I know it's big, but I didn't know it was quite this big. And so what that tells me, though, is what? What are plaintiffs going to be looking for? Are they looking for industries that are small and not making any money? No, right? So you're a target. There's no longer, it used to be, especially in Fresno and California area and Central Valley, I didn't see that many class action lawsuits. To be frank, if you talk to plaintiffs attorneys, they're not thinking the farms were with the money. They're not thinking, they're looking at, Googles and computer companies and Costco's and things like that. And that's changed. It's changed a lot. And so that's why we're seeing more and more lawsuits in ag and dairy, because they're realizing, Department of Ag and agriculture itself is huge. It's a multi-billion-dollar industry. It's one of the things, I'll be frank, even Ogletree Deakins, why they hired, they brought us on from Fresno is because they admitted to the fact that they did not represent enough of the ag community. And I think it's because, I'll give you an example. When I asked a bunch of attorneys that were in Washington, hey, who wants to come to a dairy summit with me? Talked to a bunch of dairymen, it was like, you know, a little quiet. Why? They're thinking about Apple. If I said Apple, I'd have a ton of volunteers. You know, we represent Apple. We represent all the big companies, but when it comes to farm ag community, it's a little bit neglected, I have to admit. And so that's where we wanted to come in, but it's not happening anymore. I'm starting to see there's some big firms that are looking into ag themselves to lend a hand. Obviously, let's be real, they're trying to make money themselves too, but the point is that you do need attorneys to fight for you. You have to. Because if you ignore it, I'm telling you right now, these plaintiffs' attorneys are aggressive and they don't care. And they have the laws, the laws are going against you, to be honest. The labor they're protecting labor. This is what this country seems to be going towards. Seeing more and more states. Fresno, we're the last little red section in California probably left, to be honest. We're right smack in the middle, mostly conservative. But I'm even seeing a lot of changes as Fresno gets bigger and bigger. I'm hoping the pendulum will swing back, but what this tells me, guys, is that you're on the radar. It's already known. All right, so the plaintiffs are coming. They are filing suits, and interesting enough is a lot of the immigrant labor that's coming in are knowledgeable. They know the laws, and so they're going to use it against you. All right.
All right, labor dangers, what are we protecting against? All right, so first of all, we got to worry about here is the government agency enforcement, so that's your Department of Labor. That's going to go over all your wage and hour issues and your safety issues. Now, as we all know, you know, there are some definite safety issues with OSHA and WSHA. You know, as it's been relayed to me, WSHA here is not quite as bad as Cal OSHA is, but it's still pretty bad when it comes to pro-employee practices, which is, I know for us, can take up a large amount of time for us of just protecting the employers on that one. It's you know, working with cattle with large animals, obviously you can have a lot of risks. For wage and hour issues, this is the thing. We're really going to kind of get into your strategies. Is a big part of this is going to be wage and hour issues, because with part of this is going to be there's just been a lot of, I hate to say it's been rather sloppy in the practices. That's what's kind of allowed the plaintiffs' attorneys to come after, you know, the ag industry. Is it's seen as easy pickings, because, you know, we're past the stage of a handshake deal. You know, you take a man for his, you know at his word. And, you know, we make an agreement, we move on, and those days are gone. We've transitioned now into, hey, look, this is what the law is. It's black and white, and I know technically you did provide that to me, but you didn't provide it to me on paper, so it didn't happen.
Well, how many plaintiffs' attorneys have you seen who got on the dairy, been on the dairy at all?
Yeah, I think I've seen one. I know of one plaintiff's attorney who has any connection whatsoever to the dairy industry, to ag industries whatsoever. Most of these guys that we're seeing, are coming out of LA or San Francisco. The closest they've come to a dairy is, going down the dairy aisle of the grocery store. I mean, they don't know what goes on there. They think that, they think that all the employees are being abused, that it's this horrible thing, that you guys are slave drivers and watching over the employees constantly, and not realizing that, hey, these guys have it pretty dang good, actually, and they're not watched constantly. They can take their breaks when they need to. They can move on, but this isn't the the days of long past. This isn't the days when they're being constantly abused. This is pretty well off for them. Unfortunately, the law it kind of focuses more towards the former rather than the current actual state. It's more the idealized of at least for the plaintiffs, what their idealization of what the state of the industry is. So we got to work on protecting against the DOL issues, but also so one of the things that's also come up a lot is immigration. There are some definite pitfalls that go along with that. You guys got to be very careful. We've seen the immigration, the H-2A type of situations, those can be very, very helpful. You can get a really good quantity of employees that come in that are very hardworking, that are very knowledgeable in their fields. Unfortunately, if you do it wrong, one slip up can cost you majorly. I actually have a client who is in the middle of a battle right now over a small slip up that is unfortunately has turned into a major pitfall for them. So I've seen another one that their business essentially got shut down over it. So there's nothing you can do on some of those. They're so technical, so it's got to be very careful and follow on to make sure you're following all those rules that the federal government has set up for that. Then we have the litigation and lawsuits for not just the individuals. Now the individual ones, for more often than not, are going to be fairly simple as these kind of things go. You got an allegation of harassment, you got an allegation of maybe it's a workplace violence that's happening. Some guys are getting in fist fights. Who knows what's going on? These types of things. It's what these usually go along with. That is he said, she said. Maybe if you guys are lucky, you got some cameras that are watching in these kinds of areas. But those are pretty straightforward lawsuits. The ones that kind of get really, really expensive, really time consuming are when you get into the class actions, because then you're talking about one person, and as James said, it's not your best employee, it's generally your worst employee. And they get up, and because class actions, the way that works out is that one employee, all they have to do is prove their own actions. And what happened to them, doesn't matter that it didn't happen to anyone else. If they can prove for them, they're your class rep. It now applies to everybody else. So this one person who's been the problem child of the whole thing, they're now making a big problem for you guys. And so there's a lot of that goes on into those kinds of lawsuits. Take a very long time, and it can be very, very expensive. Then we also have union organizing has been an issue in California. It's as James said, the unions in the dairy industry got driven out a while ago, but they are starting to make their comeback here. I know that we were looking up the information here for Washington. Washington's a very unionized location. Now this state is, you guys are also aware, is when you start dealing with unions, then it's a lot more issues that go along with that, right?
I think they're largest unionized employees in the United States. So it's quite a bit. Let me ask a question real quick, if I can jump in. Have people faced lawsuits here, labor employment, at all? No. Lucky. Have you guys heard of anyone that has?
Not on labor, but environmental.
Environmental is big, I know. I'm dealing with some Oregon ones right now. Oregon's crazy with their environmental. So no labor employment, that's good. I will say this, so this will be good for you guys then to kind of protect yourself when it comes to the future. And I don't want to scare you guys, but I'm going to. And one is Mattern is a law firm in LA, and I just saw an ad for Oregon and Washington attorneys for their firm. And they're the #1 filer in California. So just saying. So I do think California is such a hotbed though. They make so much money in California that it kind of keeps them there. So for you guys, that's a good thing, I think. How about union guys? Do you guys have your meetings? You guys heard about the new law, right? This changed here. Was it the 5th yesterday or something about the you cannot have your little meetings now and talk politics and things like that. In Washington, before, you guys used to be able to do that, which I always thought was interesting because California was going nuts over that. But now that no longer can you have your staff meetings and talk politics or talk religion. And before, you used to have a little powwow and do that. And now here in this state, that just passed yesterday. I guess it's effective yesterday. June 5th is the name date's coming to mind. So those little things are little movements, right? They're a little like, what is that about, right? And it's about it's called the Employee Practices something, I can't remember, Act. But basically, they just don't want anyone influencing politics or religion with their employees. Where Washington before, you guys could have a little powwow, so it's not a big deal. But I always thought that was a cool little thing, because in California, geez, that'd be crazy. You'd never do that. Well, one of the reasons I bring that up is because unions, that's where that's coming up. Is before a union, if you felt like a union was coming to town or was going to try to unionize your employees, you could sit and have a meeting, still have to follow the NLRA, National Labor Relations Act, but it was pretty much, the rules were like, hey, just don't have it too close to the ballot time to make the votes. But now that's all gone. So now you got to be careful. If you do have union, make sure you talk to attorneys, because there's only certain things you can do. It's like California, we're really regulated on that. So you can be really big trouble if you're trying to squash that. And so those are little areas that I'm seeing that's getting passed, and that just happened this year. Your guys' overtime rate got changed, right? You guys all know that. You guys are still weekly. We have to do daily and weekly in California, but over 40, but see, that's moving too, right? So those are all things that I'm seeing that we used to be the same way. California, you do 10 hours, you know, we didn't have to pay overtime for irrigators, you know, all kinds of things. Now we're all 8-hour days, you know, 40-hour weeks, and that's happening over here too. And like I said, I'm seeing plaintiffs start to recruit for other attorneys in other states, so that's telling me something. It's a little joke, yeah, that basically this usually applies, and again, like Kevin was saying, it's always your worst employee. If you ever think you have that employee that's going to give you some trouble, right, to get-go, you guys all know what I'm talking about, but you let them hang around too long, tell you in California is 9 times out of 10, that's the person that's going to sue you. Almost every single time I had a lawsuit, the owner would come back and says, gosh dang it, we knew 2 years ago, I hired that guy, he knew it was going to be trouble, but they try to, you know, work it out, try to bring him along, and it's always that guy that ends up suing. So just remember that. All right, go ahead.
Yep.
The same thing.
All right, so what's going to be the, you know, what are the plaintiffs going to go after? They're going to go after the easy targets. So you got your battery running here. So make your business unattractive to plaintiffs' attorneys. All right, well, what does the plaintiff attorney want to go after? They want to go after someone that's going to be an easy target, right? They don't want to go after someone who's buttoned down. They want to go after someone who's got, you know, got some practices that are not exactly, you know, foolproof. Now, who here uses, you know, like a time punch card with, like, it has like the stamps on it? Any of you guys use those? Yeah. I've been doing this for a while. When I get those, I'm not getting those the day of, hey, look, or the, you know, the week of, or even the month of. I'm getting them 3 or 4 years after that employee punched. Have you gone back and looked at those time cards? You can barely read those things. You know what those are good for? Those are good for, I guess you can light them on fire, you know, get a little heat that way, because I can tell you right now, they're not good for defense. Because the way that the law works when it comes to these kinds of things, that's great. The way that the law works is, unfortunately, it's not what actually happened, it's what you can prove happened, right? And so, at least in California, it's with us, it's when it comes time for defense, and we come and we have, hey, look, I can show you exactly when this employee clocked in and clocked out, and so we're tracking all their time, they got paid for all that time, but you can't read the time cards. Well, then what good is that? That employee is now, he's saying, well, no, I didn't get to do that, and I worked 12 hours a day. Well, do you have a time card that can prove it? No, I can't even show it. Right, that's one of those things that you look at. Now, a handwritten time card, those kinds of things. Oh,
Give the seizure.
a little madness over here. All right, so a handwritten time card, those things can also be tricky. Now, they're good if you can match it specifically to the employee's handwriting, but all too often I see with the handwritten time cards is that you know, maybe it's the supervisor, the person who's the supervisor, their handwriting tends to be the one that matches the handwriting of the employee's time card. Now, that's not necessarily proof of anything, but it does make it a little bit more difficult to defend against. So one thing you need to keep in mind, Ross, right? We're going to be looking at the low-hanging fruit. So those kinds of issues, those are the good ones to go after, and you go after the ones who, hey, look, there's just generally it tends to be a little bit on the sloppy side. We're not keeping track of everything. We're not, we're not doing the best practices in general, and you get a little more loosey-goosey with things. And so if things aren't buttoned up tight, well, then you look like an easier target. Because if you're willing to skimp on one section, right? So you're bending the rules a little bit over here. Well, then you're much more likely to bend the rules over here. And so plaintiff's attorney is going to see that. Now, they're not going to necessarily be able to sue you necessarily over the first thing that they see, but I know that if you're doing that, well, I might as well just open up the lawsuit and start poking around because I may find something that's going to make me some money. And because the big danger here for these kinds of practices is not necessarily what's the payout to the individual employee going to be. Because the biggest thing that we got to worry about is the money that's going to go to the attorneys, because they're the primary benefactors of this. That's why it's very costly to litigate, because not only are you going to, if it goes all the way to trial, not only are you looking at paying for your own defense, but there's also now you have the added risk as if you lose, you would also have to pay for the plaintiff's attorneys as well.
So that's the rub, right? The rub is, even if you do everything right, you have to defend yourself. So they're going to bring the lawsuit. It's too technical. You can't do it yourself. So you got to hire an attorney. Well, they get one violation on you at all. They get attorney's fees and costs. There is no reciprocal attorney's fees. I have a litigation between business to business. Both businesses have to decide, how far they want to take it. Because if you lose, usually you get them to decide to pay your attorney's fees. So you have to calculate whether you're going to defend it or not, or prosecute it. In employment and labor, it doesn't. There is no reciprocal attorney's fees. So if they lose, you don't get your attorney's fees. Now there are some little things you can do to try to offset that, but generally speaking, you don't get your attorney's fees even if you win. So in California, it's really bad. But I had to show some jury verdicts to dairymen where you go to trial and they're asking for about $1 million. And then you go to trial and the jury comes back with $3,000, right? And so you're like, wow, okay, that's a win, big time. Well, attorney's fees that they submitted was $450,000. The judge reduced it a little bit, about $380,000. So the attorneys get $380,000 on a $3,000 jury verdict, which is bullcrap, and that's what's happening. So it's the same, it's here, it's the same way. At least in Washington, you guys don't have as many penalties that can stack. California has a lot of stacking penalties. That's why you can get really out of control. But if you're talking about a class action case, and I have one representative representing all your employees, all as a plaintiff's attorney, all I have to do is put that person on the stand. I have to prove that one violation for him, right, him or her. If I win on that, then on the class has been approved as certified for everybody else, then it just, all we do is we're multiplying that by all your workers, everyone you have. And I can go back 3 years in Washington. California, I go back 4 years. Here, I go back 3 years. So that's 3 years, every pay stub, every violation, multiply that, and that's where you get, and then on top of that, you're not even done, right? You litigate this thing, it's been 3 years to litigate, 2 to 3 years, their attorneys, they get their hourly rate. So now you're on top of that, you're paying the attorneys on top of it. So a lot of times, you'll get like, hey, I'm gonna defend this darn thing. Well, I'll tell you right now, like we always say, as soon as you get sued, you lost. You've already lost. So now we have to think about damage control, okay? And sometimes that takes you, sucking up a little bit and saying, this is bullcrap, James. I'm not laying down. And I say, okay, I understand that. And I'll make good money defending you. But you can't afford it, or you shouldn't afford it, or if I get this down and settle this down at a smaller amount, and I know they don't deserve it, but it'll cost you a lot less, those are things you have to think about. So, that's what we're talking about here is, you try to make yourself unattractive. And as a plaintiff's counsel, all the attorneys do it. They're like anybody else, right? If I can make more money working less, I'm gonna do it, right? So they're gonna look at, they study it. They look at your business. They see how many employees you have. They look to see if you had any prior lawsuits before, and unfortunately they do look to see how you settled it. If you oversettled it, paid too much, that might not be good either, so you gotta balance that. But they wanna see, and then they're gonna talk to the employees. Do they track time? Are they asking you questions? Are they monitoring your guys' time? Are they giving you meal breaks? Are they giving you rest breaks? Those kind of things. If they're not, and it looks sloppy, that's where they're going to say, okay, this might be a good target, right? But if they're talking to employees, like, oh no, they're great. No, they're really strict. They're watching everything. They use, even little things like Kevin is saying, you're doing hand punch-ins. I don't mind them so much. I don't mind the handwritten ones, except there's just problems with them you gotta watch out for. But if they're doing digital technology stuff and that kind of stuff, then a lot of times plaintiffs maybe will punt on that, right? They won't. Let me find somebody else. So these are things we're talking about is creating barriers so that they don't sue you. Because you don't want to be sued. Because as soon as you get sued, you're lost already.
All right, so what are the kind of things that make dairies vulnerable? So obviously, the timekeeping practices we already went over, right? Do you have a time clock? Are you using digital technologies? Are you doing handwriting? Those types of things. Now, the payroll practices also, the daily rates and salaries, what's going on there, right? So in California, you can only do the 8 hours in a day. Now, Washington is 40 hours in a week, but you still got to track those hours, right? So even if you pay a salary, you still got to track the hours because, you know, they're still owed overtime based on the 40-hour work week.
Does anyone do salaries here? Or is it all hourly? You do hourly?
Just a couple.
Weekly?
Yeah.
Like a weekly salary? You keep track of time?
Monthly, yeah.
A monthly? You keep track of time still?
Yeah, they clock in.
Yeah, good.
Yeah.
Okay, yeah, we have that,
And there's nothing wrong with that. You just have to make sure you keep track of time. But I will say it can be a red flag, a little bit.
Well, Washington's going up to 90-some thousand.
I know.
So there won't be any salary.
Yeah, exactly. I saw that.
Yeah, so we also have issues of you know, housing allowances and deductions going on there. I mean, obviously with you know, dairymen having you know, your herdsmen, your milkers and whatnot living on the property, net pay, paychecks, record keeping practices. So disciplinary documentation, that's absolutely necessary. One thing I'll tell you guys right now: document, document, document. If it's not documented, it didn't happen. Period. Again, as I said before, it's not what actually happened; it's what you can prove happened. Right? Courts are set up, and this is not a good thing. You know, it's not right, but it's just the way it is. And reality is, the courts are set up, and very much in California and Washington, in favor of the plaintiff and of the employee. And they get up and they can get up and say, "No, I swear this is exactly what happened." Well, no, this guy, he's a liar. He was a bad employee. He got, you know, we talked to him 7 times about this exact same behavior before we finally said, "That's it," and he's fired. Okay, but did you document that at all? You didn't document it, you might as well fired him as soon as he brought that complaint up for the first time. Right? So if it's not documented, it never
Truth is
happened.
what you can prove. Right? I remember being a young attorney, my old partner told me that. I was like, well, that's just not the truth. Who cares? I was like, well, what do you mean who cares? You know, that's what I went to law school for, to fight for justice. And he goes, look, James, the truth is what you can prove, period. That's it, right? And so it goes on both sides. They have to prove their case too. But the problem is that law is about the shifting of burden, right? So you prove one thing, you shift the burden on the other side to prove otherwise. And they do it, and then the burden shifts. So think of law always as a shifting burden of proof. And like Kevin was saying, if you don't document it, any employee can go in and say, look, I work off the clock. And they're, oh, really? Well, how many times? Every day, about 15 minutes, 20 minutes, every day I work off the clock. Oh, and they don't pay you for it? Nope. They don't pay you for it. Well, do you clock in and out? Yeah, I clock in and out, but I'm always working off the clock. How do you prove that? How do you prove a negative, right? Very difficult. So if, though, you're documenting everything, then at least we can come in and make an argument that, look, they document everything. If there's time off the clock, you'll see it on their pay stub, and it'll say, hey, you know, Jorge worked 15 minutes off the clock today, blah, blah, blah. It wasn't recorded, or that's documented. We can show these things are all documented, therefore, it's unlikely he worked off the clock this time. But if I'm not documenting anything, good luck. I'm not going to be able to shift that burden of proof back over to the worker and say, hey, that's not true. You know what I mean? So that's why you've got to document. All right.
Obviously, with training records are good here for not only to protect you guys from the government's own requirements for you, but also helps establish that the employees are made aware of what's expected of them to help protect you in the future. So if they do something against normal policies, they do something that they're not supposed to, but they've already been trained on, that's something that can help you guys. And ultimately, you know, towards the end here, we have talking about language barriers. It's always a good practice to, if you have employee handbooks or any of your policies, any disciplinary forms, all these types of things, to be done in the primary language of your employees. So if you guys got a lot of Spanish speakers, make sure that you have documents translated into Spanish. You know, that way, you know, they can't come back later and say, well, I didn't understand what I was signing, I didn't understand what I was given, I wasn't aware of these policies, I wasn't understanding what I was being disciplined for. It just kind of alleviates that problem, and then the employees, you know, they're at least on notice for what's going on.
Well, We have to get through these quick now.
Yeah.
Okay, so basically, the claims are on the rise, and active management risk is the theme here, right? To be proactive in managing labor. You guys all are proactive in managing your dairies there, and your cows, and unfortunately, you have to do the same thing with your employees. This is why a lot of times we like to say, if you have, it's better to have a designated HR person, right? The smaller dairies, if the wives are doing it, or the kids, somebody, that's fine, then allow them to do their job, though, with no influence from yourself. Because you run the dairy, they run the employees. That's the way you have to think of it, because then they take their job seriously, they say or do things and have you do things and follow what they want you to do without any flack from yourself, to be honest. I think that's where I see the ball dropping. I see sometimes the young sons coming in, they went to college and now they're full of knowledge, and dad used to do this or that, and I'm telling you dad can't do that, and and dad used to do yell at people doing this and throw things out and whatever it is, and the son's saying, hey, we can't do that, and the dad's saying, hey, I run this dairy first, so this, you don't know what you're talking about. Well, what I say is, fine, the dairy is a dairy, but the HR is HR. And your son is probably right most of the time when it comes to the HR. Now, so the way you divide that up is you say, okay, you run HR. I run the dairy, you run HR, okay? You run the employees. It's better because then now you have these processes are being done that HR needs to be done, and it doesn't, hopefully, doesn't get in the way with the philosophy of the dairy and the dairy owner, the father. Now the father say, that's a bunch of crap, all HR stuff, all right, do what you gotta do. And then the wife and the son say, okay, good. Yeah, because this is how we're gonna handle it, right? And the other way is to do it through a third party. So, there are companies like HR Mobile. Do anyone use a third party HR? Whether it's doing documents, workers' comp, none of that stuff, huh? Wow, Washington is really, you guys are good. I was lucky. So you guys aren't I'm scared yet, I guess. So California, they're scared to death. So what happened is they're doing third parties, because then at least you can say, hey, I gave it a third party and they didn't do what they're supposed to do, right? And you have something you can sue for indemnity or something like that. Unfortunately, they get kind of expensive. And so that's the only bad thing. So you can do it in-house. You can do it in-house. That's nothing wrong with it. You guys are doing it, obviously. But I would recommend designating someone that's their job, and you take it seriously and do it the right way. I'm telling you guys, this is a good time for you guys in Washington, because the laws are moving exactly where California was maybe 10, 15 years ago. All right? So it's not going backwards. I'll tell you that. It's not. So you get worse. And so I just know for a fact, I've been doing this for 25 years. And if you had told me 15, 20 years ago how many class actions and PAGAs and litigation is in the dairy industry, I would have laughed. I said, I just didn't see it. Kind of like you guys are now. So, but now I can't talk to one dairyman that says anything, at least know somebody that's in a lawsuit or just handled one or selling one or something like that. So, so I would take that part seriously. Is like, hey, let's start thinking about HR, and let's see who in our either our family or group, my employees, whoever, it could be that designated person. Let's start looking at this stuff.
So also, one of the things to keep in mind here is for active management, right, is supervisor evaluation. Now, I know in the Army, what we had was a system set up with us was NCOs, the non-commissioned officers, we got evaluated twice as much as our juniors. Because if you have a bad supervisor, that's going to make things way worse for your employees, right? So you want to be evaluating the supervisors, make sure that they are good. And you should be doing evaluations for all of your employees, but especially keep a close eye on your supervisors, because a bad supervisor can quickly turn a good workplace into a horrible workplace. And as I've said many times before, a happy employee doesn't sue their employer, an unhappy one does, right?
Yeah, true. Like, that's what they teach in law school. I mean, med school. I guess med school, they have a lawyer that comes in, and all the doctors hate them. Because probably no one hates lawyers more than doctors, I think, because that's what they pay for. The malpractice insurance is so high, they get sued all the time. But one of the things they tell them is, you don't want to be sued, be nice, period. People don't sue people they don't like, people they like, and that's usually the case, and that's the case too, I think, with most businesses. And again, this kind of goes back to on the supervisors, is those are the ones sometimes, which unfortunate though, is sometimes your best foreman out there, your best supervisor, your best lead is sometimes doesn't act in the best manner sometimes, right? They get stuff done for you because they're tough. They get stuff done for you because they're strict, and I get that, but they're also the ones, and especially in the environment where we're at in California, but maybe soon, is that those are the ones that cause employees to get mad, pissed off, and go see counsel. And this is the way it kind of works, guys, so you guys understand how law works, especially in this day and age of internet. I can run a search on Google, plaintiff's attorney, Washington, labor, right? I'll get kicked a bunch of attorneys. I can click on that. When I click on that, that attorney already knows that I clicked on that. They will solicit that person and ask, hey, do you have a grievance? Is something wrong? Do you want to talk to somebody? So then if I go to talk to someone, maybe I'll go and I sign up, or I say, hey, I just have a consult. The attorney will turn that into, hey, let me take care of this for you. And what happens is when the attorney gets involved with that, it's gone. It's out of the employee's hands. It really is. It's where the attorney now, employee's like, hey, I was just mad about a certain thing. Next thing you know, the attorney turns into this big thing and maybe makes a small claim seem bigger, and then now the employee's kind of wrapped into it. Especially with supervisors, I see it all the time. Remember, a supervisor with agency law, whatever the supervisor does, you did. Sexual harassment, you're liable, right? And I don't know, in California, we're seeing more sexual harassment between male and male. I think I have, maybe you have too, right? More than male and female, which is the traditional. Weird, but that's what's happening. A lot of male on male sexual harassment claims lately. And so I'm telling you, your supervisor not behaving themselves, not doing things right, guess what? It doesn't matter. You could be the most upstanding person, run the best dairy in town, worry about your employees, all that, but you have one rogue supervisor out there. So the theme here is not only so HR needs to be on the supervisors as well, and they need to be trained twice as much. They need to be supervised, or they need to be evaluated twice as much, because that's where it comes down, right? If your supervisors are doing everything right and watching their P's and Q's and following your practices and procedures, you should be fine. Usually that's what it's going to be, because you guys can't do it yourselves, right? You're going to have to rely on supervisor leads out there that are helping run the dairy. Those guys and girls have to be evaluated, okay? Don't forget that. Yeah.
Common claims against dairies that we have, that we see are the overtime issues. Right now in California, we have the daily overtime, as we said, but also the weekly overtime. Now, as we also talked about, there's the salaried issue. Make sure if you guys are having salaries, and we only had one here, but if we are having salaries, you are still maintaining their hours and you're still tracking those. So that way you don't have any slip-ups here. Another big one that we see in California all the time is meal and rest break violations. Now, that's not an actual violation, but it's an easy claim to make, is I didn't get my meal on time. I didn't get my rest break on time. Well, that's again, plaintiff's counsel, as we said before, they don't understand dairies. They don't understand that, hey, well, I didn't get to do this. Yeah, your guy he's working in the milking barn with two other guys on his shift, and you got enough guys that, hey, you only need to have the two there. Well, you got one guy who can go take his break. They all know that they can take their breaks whenever they need to. What are you going to do? Well, I didn't get my 10-minute rest break. Oh, that's strange, because you got 30 minutes of, with these cows, and you're not doing anything, waiting while these cows are being milked. What are you doing? You're just sitting down, talking, maybe having a lunch, maybe doing whatever. Well, that sounds to me like a rest break going on. So we can also, you can bring these kinds of things up with the plaintiff's counsel. We can show them, hey, look, you guys don't actually understand the industry. These guys, they have a lot of autonomy. They have a lot of, they can take a rest break when they want to. They can take a meal break when they want to. It's not that as big of an egregious problem as you guys think it is, but this is a very, very, very common avenue of attack that the plaintiffs have, because again, if you're not required to track rest breaks, so it's very hard to disprove, and the only way you can really disprove that is also by showing, hey, look, this is not what the industry's like.
Do you think too is because it's easy for plaintiff's counsel to try to look for?
Yeah.
Right? Do you guys, all you guys track meal rest breaks in and out? Your breaks, they break, right? No? Some do, some don't, some shake their heads. Okay, so they're required to have a 30-minute rest break, right? If they work 5 hours. What attorneys are doing, and this is why I bring this up, why meal and rest breaks are always on the lawsuits, because they figured it's one area where I can pull all your time cards, and I can look to see if, for those that aren't tracking at all, you're going to be in trouble. Because as an employee, all I do is I can just have a employee come over and say, hey, you miss any meal and rest breaks? Yeah. Occasionally. Okay, well, how many times? Maybe once or twice a week. You always take it before the 5th hour? No. No, sometimes 6 hours, 7 hours, whatever. And so I'll say that, right? And as an employee, he'll say that. Okay, how many times? 2 times a week. Okay, so now I got 4 violations right there for one person. Now, remember I talked about that burden of proof? I just testify. I put you on the stand, I put the guy on the stand, and he just testifies. What does that do? That moves that pendulum back to you. Now I go, so some of these aren't tracking time. Okay, well, how do you know that back in June that he didn't miss a couple of meal breaks? Well, I just know. How do you know? Do you keep track? No. Okay, thank you very much. And you sit back down. Well, you lost. So now, if I get one, now I can go to court and I can say, Your Honor, I want to make this a class action. I want to do it for every employee that the dairy has hired for the last 3 years. And I think on average, they probably miss about 2 meal breaks a week. And I'm going to go back and I'm going to say they owe all the wages for back that time. Now, if you don't keep track, you're not going to defend it. You're lost. You're done. And it almost might be summary judgment. Summary judgment means I can do it on paper. I don't have to go to trial. I just submit it to the judge and I say, hey, judge, they don't have any proof. And the judge asks me, hey, do they have, what proof do you have? And I don't have anything. We just believe that they do, all our employees. Now, the way I counter that is I get a bunch of declarations from all your other workers and have them testify, no, that's bullcrap. We always get our lunch breaks, right? So you can fight it, but it's just a little harder. Now, in California, we have to track time. We have to track meal rest breaks required. But what happens is, in California, you have to give them an opportunity to do so before the 5th hour, but if they take it at the 6th or 7th hour, it's on them. Now, you guys haven't watched it, you have the ability to waive meal breaks, am I right? Yes, anyone waive meal breaks? Yeah? Yeah, you can.
For our store employees, you haven't signed a waiver.
Yeah, waiver. Yeah, good. I like how you say you haven't signed a waiver, because not required to even sign, but smart, right? But in Washington, I understand you can actually waive meal breaks. You can actually just waive it. I don't need one. California, you can't. I mean, you can on the 1st, you can't on the 2nd, and then even the 1st, it's a potential still violation. You should have them take meal breaks because the government wants them to take meal breaks, right? But the point being is that because it's on paper, as a plaintiff's counsel, they can look, even those that you guys record, your meal and rest breaks in and out time, they can look at it and see if it's over a certain time frame, over 5 hours. So I guess in Washington, you guys had to provide the lunch break between 2 and 5 hours, right? Something like that. So if it's over that time, we can say you're taking late meal breaks and then try to get you on that, and I can just use their paper against you. So that's the reason why paper works. It's good to have the time cards, but they also too can work against you if you're not following the laws on that too. So they can just use that. So.
Say one other thing that you guys need to really be cognizant of here is one of the rising claims that we see right now is cell phone reimbursements. Now, how many of you guys communicate with any of your employees via cell phone? Yep. Sometimes you get a text, hey, boss, I'm going to be in late. Or, hey, maybe it's the cows in pen 3 have this issue going on. Or, hey, can you go pick up this, whatever menial kind of thing. Oh, you guys are now communicating with your employees over their cell phone. That cell phone cost needs to be reimbursed, for a proportionate amount. Or what if you're, does anybody here use cell phone for timekeeping purposes? No? Okay. If you are, then that's another thing also needs to be reimbursed there. So that's a rising one. We've seen a lot of that big uptick in the last year and a half or so, as we've seen more and more of
You
these
said you
happening.
use phone? Talking now?
Some do,
Some
some
do.
use that facial recognition.
Oh, yeah, facial recognition. Do you, now the cell phones, do you reimburse for the use of the phone?
Some do and some don't.
Okay, put on that check. So what they normally practice is if you are, now, calling in, like you said, calling in, and, it gets a little gray on some of the stuff, calling the workers, but definitely if you're using them out on the farm to communicate, normally if you're using all walkie-talkies and you provide it to them, that's different. But if they're having to use their own cell phone, it's cost them, what, 60, 70 bucks a month. They have to use it technically for the job. It's like if if I had to buy a pair of boots or something, then technically you're supposed to pay for it. And so we're seeing a lot more of that, especially with apps nowadays. They have a lot of these apps. People are clocking in and out. California uses quite a bit now because they're trying to use the hand recognition, the facial recognition. That's kind of expensive. The hand stuff doesn't work because none of the thumbprints are actually show up, right? And so they're doing the apps now because everyone has a cell phone. But what they're doing is they're not reimbursing. And so we always say, hey, put $5 or $10 on their paycheck for that month. That'll cover, that's a percentage of their, it's basically, the idea is what percentage of their actual phone they use for your work. And that's really small. And it's probably come down to like $1 or $2. But we say to be safe, do $5 or $10. And if you're using it all the time, maybe more. Or the other way is you provide them the actual cell phone like you would your boots and your aprons and stuff. But that is a big claim I'm seeing lately. We're seeing a lot more of that. Again, guys, what it is not how big it is, it's the hook, right? Because they get attorney's fees. So if they sue you and it's $5 and it costs them 50 grand to sue for $5, they're getting 50 grand for attorney's fees. You can ask for adjustment with the judge, but would definitely do not rely on that, especially a lot of the more liberal judges that are being put on the bench are not, they don't tend to decrease the attorney's fees that much at all. All right.
All right, make sure you guys do your investigations need to be prompt, and you need to be making sure you guys document the investigations for any workplace harassment kind of claims. Treat everything as though it is a actual serious complaint. Now, I know you may not, when your employees comes to you and it's seems like a rather trivial matter, and so you're like, it's not really worth looking into. No, the best practice here is treat everything, no matter how small, treat it as though it's serious. Now, your investigation may come out, it actually is nothing. Okay, no harm, no foul, right? But I mean, I just came off of, I had a workplace investigation I just did about 3 weeks ago. We went in and it was a rather menial kind of complaint, and it ended up uncovering that this supervisor actually had a long history of abusive behavior for not just this employee but many employees that should have been terminated a long time before. So you can actually, if we had treated it like it was a nothing kind of complaint, then we wouldn't have uncovered that, and it would have been a much more egregious liability type of thing. So. You got to treat every complaint as though it is a serious accusation, and also you have to make sure you document the entire investigation. As we said, document. If it's not documented, it didn't happen.
I'm curious, how many of you guys have handbooks, employee handbooks, written? Couple? Not everybody though, huh? Okay, employee handbooks is one of those higher documentation, because then what that tells me is that how many of you guys have a grievance procedure? Where am I supposed to go if I'm on your farm and I face sexual harassment? Some guy comes over and grabs my butt. What do I do? Do you guys have a procedure for that? Who do I talk to? Who do I go to? Those are all things you have to have. You need to have a procedure, and usually that's documented in a handbook. A handbook's like, it could be big, 20 pages, it could be 40 pages, it could be smaller, but at least have a handbook that has a procedure that you give to your employees that signs off on that, says, okay, here's our policy and procedures. That way, you have a defense. If you have a lead or someone that goes and harasses someone, but they're not following the procedure, your defense can be, hey, I didn't know. Now, what they're gonna say, remember that pendulum swing back and forth, what they're gonna say is, well, I didn't know where to talk to. So then you'll lose there. But if I say, no, I have a policy and procedure, and this is what we're gonna, and this is what you need to do, this is who you talk to, did you talk to that person? Yes. Okay, and then you go and you investigate, you can look at everything, you find out, oh yeah, that's what happened, you can fire the guy, no liability. All right, no liability. You did what you're supposed to do. But if you don't do that and you don't follow procedures and you find out down the line and some person is doing these things and you had no policy or procedure to kind of weed it out, then you're going to be liable. All right? Yeah.
So Dairy Gold provides WAFLA, you familiar with WAFLA?
Yes.
And we have a free hotline for
Nice.
producers and for the employees.
Nice.
And they work on hand.
And you pass out something that they all have that number, right, to call?
Yeah.
Yeah.
I don't know how many use it.
Yeah.
Use it, but it's available,
Okay.
and Dairy Gold pays for it, so
Good.
we have something.
And Dairy Gold, then whoever's there usually has someone to talk to.
Yep.
Hey, we had a call, this problem.
Yep.
And so that provides your defense. And now I can defend against that because you can't control all your leads and stuff out there doing something stupid, right? And so, but because you had that process, and now someone had an employee had that going on, and then they sue you, and they say, how long has it been going on? 6 months, a year. Okay, did you follow? Did you call WAFLA? Did you have our contact? Did you get a hold of someone? No. Well, okay, I didn't have notice.
Right.
So now I have notice, and now I take action. Now there's no liability. So those are little things you can do to give yourself a shot to defend against that. So it's good to have. Let's just go quickly because we're going to run out of time, I think, here. The wage and hour gold rush. The reason I'm here again, I'm scaring you guys for a reason, not because I'm telling you it's coming. It's coming down, and maybe if I get to speak again a year from now, you guys will have more hands. Like, oh yeah, we got hit. Hopefully not. But I'm saying is that it's the collective action is a gold rush for these plaintiffs' attorneys because they only need one bad employee or one employee to make a complaint. And then from there, I can actually get damages for every other employee that doesn't even want to sue you. Right? Now they can opt out of the process, but most of the time when that comes down is just a little pay. You guys get those little things in the mail from Wells Fargo lawsuit or something, right? And you end up getting like 35 cents or something, right? Because Wells Fargo, illegally takes fees from us all the time. But anyways, they do. Every time. I work for a bank. I represent banks for a long time, so I kind of know a lot. But yeah, and so they get the same thing. Well, how many times do you take that and throw in the garbage, right? You're not going to fill that out. And so a lot of times it's an opt-out process. Federal court is an opt-in process, meaning they actually have to fill the card out to get paid. And state court is an opt-out process normally, so normally that they just throw it in the trash, they're going to get paid. So what happens is your damages ends up being everybody. It's usually rare. I don't think maybe 2 people might opt out. So usually people just oh, I didn't even see it. They're good employees. They love you to death. They just figure, well, if I'm gonna get $40, great, $40. Most of these are not getting that much, right? $200, $300, maybe $1,000 each for attorneys. But the attorneys' fees are $800,000. 400,000, that's who's making the money. So, anyways, that's why I'm trying to scare you guys on this class action.
Common risk management tools here. So handbooks, as we talked about. Make sure you guys have the protection plans and risk specific programs, so you guys are prepped and ready to go. So that way, if you have any, you guys can identify the hazards and the normal pitfalls, and so you guys can address those, and so that way it limits your liability. Make sure you guys are doing your training. Now, it's always good to have training on sexual harassment, things like those, as well as training on the different safety procedures and processes for your specific dairy. Those are just good ideas, good practice to have, regardless of whether the state tells you to, because it's just, we want to limit the general, general problems that can happen at a business, and the best way to do that is just train your employees, make sure they're taken care of. And realistically, insurance is always a good idea. I know it's additional money that goes out, but at the same time, that's if one of these kind of lawsuits does hit, It's better to come out of the insurance pocket than yours. We see a lot of EPLI in California has become a lot bigger deal for the dairies as they've come up with sexual harassment suits that are being tagged on, and we start seeing some wage and hour type of things, but they'll also throw in allegations that would fall under an EPLI policy, specifically to kind of trigger any potential insurance coverage to kind of make things a little bit more profitable for the plaintiffs.
Do you guys know what EPLI is? You guys have that? Anyone have that? It's employment liability insurance. So they have that in California law. It usually covers the sexual harassments and things. So I know they have it in Washington too, because I've seen it. But it might be wrapped up in one of your general policy too, that you guys don't know. There might be a provision in there. California is doing that. Insurance is a way to do that. Everything we talked about, those things having in place to make yourself not a target is important, and the insurance obviously can help you. The only problem with the insurance sometimes is that it can get so expensive. Insurance usually protects themselves, and they'll have this retention amount, which says, okay, you have to spend your own money, about 50 to 100 grand before we come in and start, covering it. The good thing about that, it covers you for the big lawsuits, the ones that would bankrupt you. So insurance is always a good thing. All right. And then also too, make sure you guys, one thing I want to talk about the APP, the accident prevention plan. Those days back in the day of the dairy, hey, you come on and you learn, right? Get out there, don't get kicked in the head by a cow, don't get smashed in the corrals, don't all that stuff, right? All on the job training, right? All that stuff doesn't fly anymore. So I get a new guy, comes out there and he does something dumb and he gets hurt, right? It's going to be on you. Now, the good thing about Washington, you guys are all required to have the L&I insurance, right? And so that becomes exclusive remedy, so they have to go under that. But there is some little caveats where they can go outside of that and sue personally. But have a accident prevention plan in place, meaning that you're doing your trainings, and you're documenting how every job that you have on the dairy there should be documented. And that's another thing too, or like HR to start thinking about doing, and also creating job descriptions. Because job descriptions are important when I have a disability claim and I'm saying, hey, I can't do this, and then you're saying, well, I have to fire you because you can't do this job, and I don't have a description of the job they're doing, and I'm saying, hey, he's making this stuff up, I could do this other job, and they're not hiring me because they think I'm faking it or malingering or whatever, or they're legitimately hurt, but I can't be discriminated against because of my disability. And you say, well, I can't give you that job because you can't do it. Well, if I don't have a job description written down, a little harder to come back after the fact to say, hey, no, that job entails this, 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 and this. Because as on plaintiff's side, I'm going to say you're making it up. You're making that up now. You're really discriminating because of disability. That's not, you have jobs on the dairy that this person can do, but if I don't have a job description of all these different jobs, it makes it a little harder for you, okay? So things like that, think about doing as well. Okay. Okay. We have 4 minutes?
Yeah. So generally, good record keeping. Make sure you guys are tracking all the times your employees work. Do some periodic audits. Examine the available technology. Show them their time records. Make sure they get acknowledgments on their times. Honestly, one of the best practices you guys can do when it comes to timekeeping practices is have the employees sign off on their hours at the end of each pay period. So that way they can't come back later and say they worked more hours than what they were actually being paid for. It's like, well, that's interesting because you signed off saying that you got it. Employee handbooks are always good practice, along with the AAPPs, as he was just saying. Now, I know you guys may think that it's kind of dumb. Why are we getting into such specific policies and practices for these guys? It seems like a lot of these things are pretty self-evident. Just remember that you're talking about the latest generation of workers that are coming into the workforce, are also the same generation of people who had to be told to not eat Tide Pods. So it may seem like it was a kind of a dumb thing to do, but yeah, you do need to break it down for them. Human resources and internal monitoring. As I said, it's a really good idea to have human resources dedicated personnel, or have a third party to come in and check things for you. Make sure that you guys are training all your employees and your supervisors, especially your supervisors. It's imperative that they get trained on all these things. One of the best things is we were talking about low-hanging fruit, right? That what the plaintiffs wanted to go after. They want to go after people that are going to make easy class action lawsuits. The number one thing that's going to help against that is an arbitration agreement. An arbitration agreement says that employee agrees they're not going to be doing those kinds of cases. And so a plaintiff's attorney sees that and they go, oh, this isn't worth my time, and they'll just skip on the case a lot of the time. We've gone over that.
I'd like to go back. Yeah, I think we're kind of a lot of repeat stuff there. Who has arbitration agreements? Anybody? Derrickle, do you guys don't have arbitration agreements?
Yeah,
No?
I don't know what we have.
I'd be surprised. Okay,
I think we do.
arbitration agreements are key.
Legal
And the reason why is not that, anyone know what arbitration is? You guys have any idea? Okay, so.
You come to the table and talk before you go to the court?
Kinda, that's mediation, yeah, so there's mediation, which is non-binding, means you come to the table and talk, you hire somebody to be a neutral for you. I always try to find someone in the ag industry if I can, and the plaintiff side tries not to, but, and then you come to the table and try to talk, and we're doing a deal, so that's mediation. Then there's arbitration, which is the same thing, but binding.
Right.
So that person becomes the judge.
We
And
have,
that-
we have with the union.
Okay, yeah, union has their own grievance process. But arbitration agreements are important because of what they have in them. And the big thing they have in them is called class action waivers. So what happens is, under federal law, you can actually make it a condition of employment. So either sign or don't work for me. And in the class action waiver, what it says is, you agree you will not sue as a class action representative. Huge. So I have a plaintiff thinking they're gonna make millions of dollars, they file a lawsuit, and we come back to, hey, guess what, you guys signed an arbitration agreement, you have one claim, you're an individual person, that's it. Right? Huge. I mean, so big is really could go bankruptcy or settle it and keep moving on. All right? So arbitration agreements, you really need to look at that, you need to grab one, and you should have your employees sign them. You guys all sign them. Look at anything you have, your cell phone, AT&T, Verizon, all that, arbitration agreements, every single one of them. And if you read them, you'll see in there, it says you can't be a class rep. So that's why they're doing it. Arbitration is expensive, which I don't really like, but it will keep you from having the class action. All right?
We're good.
All right. Any questions? A lot of stuff.